proceedings of any nature whatsoever will be commenced against Nelson in respect of any matter arising out of his notarized statement. Al-Rawi agreed to indemnify Nelson from all actions, suits, proceedings, claims, demands, damages, costs, expenses, and liabilities whatsoever, which may be taken or made against him, or may be incurred or become payable or sustained by him by reason of the breach of any of the undertakings contained in that indemnity agreement. This is what was coming out in the public domain, and questions were being asked of the then Attorney General and of the government, the Prime Minister and other members of the government. Public concerns did not end there. The Attorney General has no jurisdiction, and this continues to be the crux of the whole dispensation of Faris Al-Rawi. One wonders, he as Attorney General did not have jurisdiction in negotiating any plea bargain in any type of criminal prosecution, which remains the exclusive domain of the Director of Public Prosecutions. I say this again in the context of concerns which were arising over the period of time 2019 moving forward, and particularly 2021. So any attempt to engage in any such action would have amounted to misbehavior in public office. This was the contemporary commentary of the citizens at the point in time. So if the Attorney General did not, and these were questions that the public was asking, if the AG did not recommend to the DPP that Nelson not be charged, then by the terms of that agreement, at that point in time, what we were seeing to be an agreement, and we were asking questions about this indemnity agreement, the state will be in breach of the agreement, and the state, the taxpayers of this country, will have to foot a fine imposed on Nelson by the court, as well as any other damages that he may have suffered. The actions of Al-Rawi at that point in time, and based on the knowledge that we had, we were raising his actions may not only have contaminated the evidence in the case, in the substantive criminal proceedings, but also exposed the malice. It went so far as to expose a malice on their part in terms of how they were treating with criminal matter, a criminal proceeding, which again I must emphasize they had no lawful authority to involve themselves in. And what was the objective? The concern again was the objective for engaging in that manner in the criminal proceedings back then by giving Nelson this indemnity agreement could only be that you were seeking to persecute. You were ensuring, you were overzealous, you were over enthusiastic about going after political adversaries. And that is not what government power, the exercise of government power is about. So though concerns were raised over these newfound knowledge at those respective points in time between 2019 and 2021, neither Al-Rawi nor Prime Minister Rowley addressed these public concerns. Al-Rawi's actions exposed the rot of executive unlawfulness, and that is now being used by the PNM to silence their political opponents. This is what we are witnessing today. The DPP denied any knowledge of this plea agreement, saying he was not privy to any discussions which would have taken place before the criminal investigations were conducted. The only agreement which DPP Gaspard says he's aware of is the criminal plea agreement. He is not aware of that indemnity agreement. Ladies and gentlemen, we fast forward to Monday, 10th October 2022, which was last week Monday. The case against Anand Ramlogan and Gerald Ramdeen collapsed. The case collapsed. That is exactly what it is. So, I want to turn to the constitutional ramifications for Trinidad and Tobago. There are serious constitutional ramifications when we consider what has been said and done by the government's Attorney Generals, both former and present Attorney General, the Prime Minister, the Minister of National Security, Minister in the Office of the Attorney General, Senator Sagram Singh, and Minister Stuart Young. And we will touch on the dangerous implications for the rule of law and the integrity of our justice system, the public's overall confidence in the administration of justice, and the consequences as the Constitution affects the lives of our people, you and me. Let us look at the Constitution a little bit. And let me talk briefly about the provisions of the Constitution. Of course, it provides that the Republic of Trinidad and Tobago shall be a sovereign democratic state. That is something that people take for granted, but it cannot be emphasized enough. Our Constitution recognizes that men and institutions remain free only when freedom is founded upon the respect for the rule of law. As a constitutional democracy, our sovereign democratic state ought to be dedicated to the rule of law and the fair and impartial administration of justice. The means by which this is achieved are simple but powerful. And how do we do it? We have created institutions which operate according to law and its just interpretation and application of the law. Courts which deal even-handedly with everyone, no matter their race, their creed or color, social status, or how much money they have. This means that the law under the Constitution is supreme. A man or a woman cannot intervene and set aside that law for their own personal preferences. And I turn quickly to Section 90 because it is topical yet again in this whole scandal. Section 90 of the Constitution, which deals with the Director of Public Prosecutions. I want to say that a major part of the mechanism to achieve that even-handed application of the law, which I was referring to earlier, is found in the independent office of the Director of Public Prosecutions. He is charged to make decisions based on fact and law. He or she must not be swayed by political forces or personalities to make decisions for political ends. Ladies and gentlemen, I make passing reference to the cases of Singh and the Attorney General and others. That is a High Court action number S395 of 2001. Of course, the Court of Appeal of Trinidad and Tobago in the state versus Siromani Maraj Narayan Singh and others. That is Criminal Appeal number 5 of 2006, which followed the Privy Council in AG of Fiji versus the DPP, a 1983 weekly law reports Privy Council decision. There are other helpful decisions of Matalulu versus the DPP and G1 Mohit versus the DPP of Mauritius, Privy Council Appeal number 31 of 2005. If time permits this morning, if it permits, Mr. Sobers and I will delve deeper into those cases. But what is clear, and the point I want to make is that the DPP, and this is what the case law throughout the Commonwealth, and particularly because different regions, different countries have different systems, it has evolved differently. But particularly the Caribbean Commonwealth, the DPP has full control over all criminal proceedings. So don't listen to Mr. Faris Al-Rawi in his press conference last week and as though casting some kind of gray area in which instances the Attorney General can find himself involved in facilitating, whatever language he chooses to use, facilitating the progression of criminal proceedings. The DPP, it is written in black and white in our Republican Constitution at Section 90. I think it is Chapter 6. The DPP has full control over all criminal proceedings. And what is even clearer based on the case law, our constitutional arrangements and practice and convention, is that the DPP enjoys prosecutorial insulation. So the DPP enjoys prosecutorial independence. That is the institutional separation from the executive arm of the state. And by that I mean it enjoys insulation from the government. In simple terms, ladies and gentlemen, it means whomever is in power cannot seek to use and or interfere with the DPP's office so as to prosecute political opponents. It is therefore critical that we as a nation, as a people, that we safeguard the independence of the DPP at all times. This is what will ensure that the justice system remains dedicated to serving the public's interest. But this PNM government has no respect for the rule of law and therefore has no respect for the independence of certain institutions. You will recall a very clear example of this occurring when none other than the Prime Minister subverted the selection process for a police commissioner with the withdrawn merit list. That is very fresh. The wounds are deep and still raw, arising out of that scandal in its own right. The Prime Minister's own disrespect or lack of respect for independent institutions resulted directly in the collapse of the Police Service Commission and this country continuing to be without a substantive commissioner of police. Ladies and gentlemen, I go no further with that. The series of events which Mr. Sean Sobers and I are about to describe this morning will reveal in the clearest terms a government which clearly has interfered with the criminal justice system. It has used the criminal justice system as a vehicle to advance partisan political interests. It has manipulated the criminal justice system to become a weapon for persecuting and punishing political opponents. That is what we are seeing, the conduct of this government. I want to turn now quickly to the PNM's history of interfering with independent institutions. You see, this did not start yesterday or last year. There's a document called the Report of the Mustil Commission of Inquiry, a tribunal set up to investigate former Chief Justice Satnarayan Sharma. I would encourage all our citizens to read this document as it outlines just how institutions can be manipulated and how indeed they were. A Prime Minister, a Chief Magistrate and others colluding to unseat a sitting Chief Justice. A former PNM Attorney General attempted to unduly influence then DPP Jeff Henderson, interfered with former Prime Minister Basdev Pandey's trial by having secret meetings with the then Chief Magistrate Sherman McNichols. Let us not also forget the prosecution of our own world-renowned local-born Professor Vijay Narayan Singh. I move quickly along to the recent Privy Council ruling which quashed the Piaco 1 criminal case, saying, and this is what they said essentially in that Privy Council ruling, that the then Chief Magistrate, the late Sherman McNichols, had been hopelessly compromised by then PNM Attorney General John Jeremies, and he was seeking help to get Clico Company to repurchase McNichols' land for $400,000. As a consequence of that ruling, it now falls to the DPP, our present DPP, to decide whether or not to restart that case. True to PNM form, in an almost immediate response to the Privy Council ruling, Senator Sagram Singh, and this is the course of conduct, you've seen it coming around again and again, Minister in the Office of the Attorney General, promulgated an unsolicited opinion. The Privy Council ruling came out at one day, and within mere hours, she solicited an opinion as to whether or not the prosecution should continue. I pointed it out then to the population, and I will point it out today again. Her actions are tragically yet another classic example of executive overreach, interference, and abuse of the DPP's office by this PNM's government. I want to stick up in at this point to say, and I will change my tone, that the Council of the Law Association cleared Senator Sagram Singh within record time, within mere hours, on that occasion when we said that she was attempting to influence the DPP unduly. On this occasion, we may have to wait weeks, if not months, if not at all, before we hear the Council of the Law Association say anything on this Nelson indemnity scandal. I repeat my public call, which I made last Thursday on 13th of October, to the Council of the Law Association to state its position on this ongoing fiasco. Based on their past releases, it is highly likely that the Law Association will first have to say that they are being attacked by politicians. And that is why I changed my tone, because we are not attacking you, Law Association. But you see, we in the UNC, as the alternative government, government in waiting, we are simply acting in the welfare of the citizenry. And we ask that you, Law Association, Council of the Law Association, you do the same. Nothing more, nothing less. So I want to return now to the point that the PNM has a long tradition of interfering with the DPP and other independent office holders. It is clear that they are now hell-bent on continuing their unlawful and scandalous practices by seeking to induce and or potentially bribe and or by any questionable and suspicious means possible secure the attendance of a cruel devil, a Shylock of Trinidad and Tobago, one Vincent Nelson. PNM's government strategy of persecuting Ram Logan and Ramdean. That is what I want to talk about now. Ladies and gentlemen, I want to remind you that the former UNC Attorney General Anand Ramlogan, when he was charged, publicly said he wanted the matter to get to court with dispatch so he could defend himself against these preposterous charges. But you see, there was the strategy. The justice system is slow to the point of glacial. Charges hang over the heads of the accused for years before they are finally dismissed and shown not to have been brought at all. This gives a strategic advantage to those who would manipulate the system. If you can cause charges to be laid, you in effect place the accused in limbo for years, perhaps decades. This is not just politicians, you know. We all know the tragic cases of young men languishing in jail for years, far in excess of the maximum sentences for the crimes of which they stand accused. So the PNM's modus operandi is to interfere and to influence charges and hopefully keep you before the courts as long as possible, all the while calling you a thief and a criminal. But you see, there is something here that we are getting into deeper. There is a conspiracy to persecute political opponents. I want to hand over to my esteemed colleague, Mr. Sean Sobers, who will advise us of the events which clearly point to a conspiracy between A.G. Al-Rawi, Prime Minister Rowley, and other members of the government, among other things, to persecute Ram Logan and Ramdean. Mr. Sobers, I would like to hand over to you at this stage to, of course, enlighten us on some of these finer details in this Nelson indemnity scandal.
Thank you, MP Rambally, and good morning to Trinidad and Tobago. Now, two of the very salient points that MP Rambally would have pointed out in his contribution, I want to reiterate and repeat for the benefit of the members of the media, for the benefit of all those persons viewing and listening to us currently this morning. The PNM has chosen to do two things of which our Constitution robustly speaks against. Two things that in any democratic state or society, right-minded persons would speak out against. And that is their ability, through time, tested, demonstrated, and exemplified in this particular scenario, to weaponize systems of democracy which should not be. I want to repeat that. Their ability to weaponize systems contained in a democracy of which they should not be doing. Another one of the salient points made by MP Rambally is the PNM's ability, but in this case specifically tethered to one Faris Al-Rawi, to overreach his executive powers, to overstep his executive boundaries. He has gone so far past those boundaries, so far past that line, that the line is now a dot to him. That is the position that he is in currently. That is the position that the government of Trinidad and Tobago has found itself in by these backdoor dealings that have now come to light. I mean, we are all Trinbagonian citizens, and we are aware of what the old people say. What you do in darkness one day will eventually come to light. And it came to light on that fateful day on Monday, this past Monday, when those charges were dropped. And then a chain of events which demonstrated, which illuminated, which lucidly demonstrated to the public what was actually transpiring behind closed doors. Now, just like MP Rambally and all the other members of the alternative government in waiting which we belong to, we listened, unfortunately we had to the press conference held by Faris Al-Rawi, MP for San Fernando West. And he made heavy weather about his position as he then was as Attorney General, and the fact that he didn't cross any lines, and that as it pertains to criminal prosecution, he appreciates that it falls within the remit of the DPP, and as Attorney General, he had certain powers and he did what he was supposed to do. MP Rambally would have lucidly indicated what the Constitution says the powers are connected to the DPP. Let me read what the Constitution says the powers are as it pertains to the Attorney General. And it is found in our Constitution at section 76, 2 and 76 and 79, but specifically 76 2A. The Attorney General shall, subject to section 79, be responsible for the administration of legal affairs in Trinidad and Tobago, and legal proceedings for and against the state shall be taken in the case of civil proceedings in the name of the Attorney General. Right? That is the responsibility of the Attorney General. That is his responsibility with respect to civil proceedings. All criminal prosecution has to be under the remit of the DPP. And it is because we are a democracy. It is because we are rooted and anchored to demonstrating independence away from an executive and tyrannical law. That is why our Constitution was framed in that particular way. But as the saying goes, power corrupts and absolute power corrupts absolutely. This is a clear example of that. It is a clear example of overreach, which, as MP Rambally would have indicated categorically, did not start today. Examples of the PNM overreaching is something that has been plastered over several different outlets, several different media outlets, several different examples playing itself out within the public domain. Let us not forget, let me remind you clearly that in March of this year, we were all under the impression, as far as I was, that the former Attorney General may have been removed because of another example of overreaching with respect to the imbroglio, with respect to the scenario that he found himself in with the CPC of this country, the Chief Parliamentary Council, that occurred in March of this year. And that particular position with respect to what occurred with Senior Counsel Ian McIntyre and Faris Alrari remains unchallenged. For months, we would have called upon the administration to indicate what their position was in relation to that issue with the CPC. And for months, the administration remained quiet. And we all wondered why. Why it is that the Prime Minister of this country did not indicate what was his position with respect to that imbroglio with Faris Alrari and the CPC. Why Faris Alrari himself never came out and gave a statement as it pertains to that letter that found itself within the hands of the media and all members of the public with respect to his outlandish conduct as it pertains to him dealing with the CPC, interfering in that particular office, overreaching in that particular office. Why he didn't come out and say something. And now we have to wonder if during that period of time, these revelations with respect to sweetheart and backdoor deals may have found themselves in the hands of the cabinet, may have found themselves in the hand of the Prime Minister. And that may have been the reason why, respectfully, certain actions would have been taken as it pertains to removing him from his office. And I would have said it facetiously on another occasion, and I say it now clearly and sternly, that sometimes Faris Alrari, if it is you possess certain acclamations or belief that one day you could become the leader of the PNM and maybe the leader of the country, this is definitely not the way in which you go about doing so. Because clearly now you've jumped from the frying pan into the fire. This is what is happening now. And as we listen to that press conference that he had, where he carefully attempted to indicate that, listen, I'm not going to go into too much of this thing because it is sub judice, and he's aware of that Privy Council decision in Nankisoon Budram and with respect to undue publicity. He's aware of those things, but he was careful to go into material information connected to what Nelson gave in terms of statements, particularizing certain alleged incidents between himself and Messrs. Ramdeen and Ramlogan. You don't want to talk about undue influence and undue publicity, but you spoke about those issues. And the real questions that the media wanted to ask you dance around those things. So in true contrary fashion, he operated at that press conference. And he indicated that he became aware of these issues with respect to Messrs. Ramdeen and Ramlogan. And I ask you today, Faris Alrari, tell the country how you became aware. Who told you about those issues, those allegations? Who brought those things to you? And knowing what you knew, or what you became aware then, why did you not do what the Constitution indicates lucidly that you had to do? As soon as you become aware of criminal activity, we say it all the time, they say it all the time,
If you know something, some crime happened, where you coming to ask me about that for? Go by the DPP. Go by the police. They quick to say that. And rightfully so. But why now? Or then actually, when information of that nature fell on your lap, however it did, enter your mailbox or whatever the case is, why you did not go to the police and inform the DPP straight away? In your own words in that press conference, you indicated because you became aware of this information, seized and possessed, you went to Silk to get some advice from them to settle an indemnity agreement. And I want the population to understand, because sometimes he attempts to use legalese and persons may not understand. When lawyers say things like settle documentation, it essentially means that someone else drafted the document and then you send it for somebody else, maybe more senior, more okura with that particular area of law, to review it and maybe make some amendments and confirm the document. So the question remains, who drafted that agreement? And again, at all material, I want to continuously point that out to the public. At every turn of the dial, at every step of the way, the person with the responsibility and the authority based upon the Constitution to deal with criminal matters, of which this was the DPP. So no drafting of no agreement should have been in the hands of Faris or whoever else he gave, if he draft or whoever draft, none of them should have been drafting that. It should have been the DPP. Nobody should be settling anything but the DPP or somebody under the strict instruction of the DPP. And in terms of the drafting of the agreement, MP Rambally would have read out some parts of that indemnity agreement. It is poor drafting. It is the worst thing that you could have seen being placed upon a piece of paper. You are the person responsible under 76(2), as I read it out, with respect to what your responsibilities are civilly. And you are putting in an indemnity agreement at clause 4 of that agreement that the Attorney General undertakes to recommend to the DPP, who has the power to determine whether any criminal proceedings can or will be commenced against you, meaning Nelson, in respect of any of the matters arising out of the notarized statement, the statement that you gave to Faris, that no criminal proceedings be commenced against you. How could you put that in writing? We heard somebody the other day talking about batting your crease. You should have batted in your crease. You cannot make a promise like that.
Yes.
That is not your remit. It is not your responsibility. And then in section 5 of that same agreement, I wouldn't read out the entire thing. It's there for public consumption. You're basically indicating to this man that you're going to pay him all a set of money. Any suits, any civil, this, any that, you pay in that. As far as I'm concerned, those things generally would amount to you inducing somebody. And there's an act that deals with respect to inducement as it pertains to procuring information from a criminal witness. And that's why I asked the question, who drafted this indemnity agreement? Right? Was it you? Was it the state, some arm of the state? Was it Nelson himself or his lawyer? We want those answers. And as I said before, it was improper that it was drafted by any of those persons, because it should have been drafted by the DPP. The Constitution is quite clear on that. And as I talk about improper conduct and inducement, as I make mention of that, I want to make this clear for Trinidad and Tobago. It is a fact, well known and well established. From time to time, before I was a permanent senator in 2019, I used to sit temporarily in the parliament. I still do. MP Rambally indicated that. And thereabouts in 2017 or 2018, I can't recall the exact year, there was in fact a bill, and I want the public to understand the devious and deliberate nature. Some persons would say, wicked, I say devious and deliberate nature of the PNM in terms of what they're doing, and weaponizing, as I indicated at the beginning, weaponizing systems that ought not to have been. A flurry, a plethora of legislation, criminal legislation, coming to the Parliament, coming to the Senate, coming to the House, with respect to criminal activity, and all of them under the guise that it is a suite of legislation geared towards dealing with crime and criminality in Trinidad and Tobago. And we wondered, yes, we knew crime was out of control, this set of legislation coming. We said, well, you know, let's go it through as we would do as a responsible opposition. And one of those pieces of legislation was this plea bargaining and plea discussion bill.
And in terms of that particular bill, there were, as per usual, several gaps in the bill. And as per usual, as a responsible opposition, we advance proper amendments, never before seen in terms of the history, but based upon the instruction of our leader, Mrs. Prasad Visesa, we advanced those amendments and they were accepted. And one of the amendments that we raised, we indicated, listen, you are now bringing for the first time before this country plea bargaining, plea discussion agreement. We want to ensure that when an individual comes to the DPP or the police, which is what the act says is supposed to happen, not the Attorney General, that the person is properly well vetted and the information that is procured from them is vetted as well too, to ensure that it is true as best as possible. And in the event that it is not true, that there is some type of inducement, there should be a sanction placed within the body of the legislation to treat with that. And they kick and they fight and they bawl and they squirm, and we had to drag them to accept that amendment, but they eventually did. And that amendment was made law, and it is actually found in section 13. And what it says is this: an accused person who enters into a plea agreement shall be entitled to withdraw from that agreement before sentence or to appeal against a conviction based upon the agreement if A, it was entered into as a result of an improper inducement. That is the law. And I can't see any reasonable, right-minded, red-blooded Trinbagonian citizen having read this indemnity agreement drafted by a 5-year-old, in my opinion, cannot connect the dots to consider that this document is possibly, more than possibly, in fact, an inducement. And that is why we have called upon the DPP, and we will continue to call upon the police as well too, to investigate this matter. Whether or not that document, its construction, its usage was in fact improper, and whether or not it does in fact form an offense in terms of inducing someone to give a statement. We want the DPP and the police to investigate that. And in that press conference, MP Arari as well too, he went on to indicate certain things that, well, that the document was drafted and that the document was sent to senior counsel for settling. And he called senior counsel, so I have respect for senior counsel Mendes and senior counsel Peterson. But we really want to find out from them, because at the end of the day, I am certain taxpayers' dollars would have been advanced to those individuals for them to settle that document, which is fine, but we need the advice that was given. It is important, it is critical at this stage for us to procure that advice, to understand what their positions were. Not to cast any aspersions, but we need transparency and accountability. And that is why we need that advice. And as it pertains to matters now that have been in the public domain, we saw a release from MP Young coming out based upon what has been plastered in the newspapers. And he speaks to him not wanting to go into certain things. He indicates it is also noteworthy that thus far no report has referred to the defense that has been filed by the state in this matter. This is the matter with Nelson versus the state for this breach of the indemnity. I really want to ask today, who are the lawyers representing the state in this matter? Who are the lawyers that filed this defense in this matter? Who are the lawyers advising the state now in defense of this indemnity agreement breach? I want that information. I want the powers that be, Faris et al., to come out and tell the public who lawyers are representing the state with respect to this breach. It is very interesting, and I want them to come out and indicate that. At the press conference, he also indicated that he signed this indemnity agreement and whatnot and whatnot. And I asked him today, because MP Hussein would have written a press release as well to yesterday concerning that. When did the cabinet become aware of this agreement? He tried to dance and dodge the question when asked at the press conference. And even the Prime Minister at a meeting tried to dance and dodge and didn't want to indicate. But there was an Express article that came out mere days after that clearly indicated that the former Attorney General Faris Al-Rawi had indicated to local law enforcement, meaning the police, that he discussed the Vincent Nelson case with the Prime Minister and 4 other government members. And that was based upon a number of questions sent to him in August and May of this year by the DPP, right? And one of those questions was asked, did you discuss the Vincent Nelson case with anyone in the government as might be expected, the case involving Anand Logan? And he says to them in that response, yes, I discussed this case with the Prime Minister, Minister in the Ministry of the Attorney General and Legal Affairs, Stuart Young, Fitzgerald Hines, Renuka Sagram Singh Suklal, and Reginald Amor SC. So when did this discussion happen? At what point in time were they aware of this indemnity agreement? Were they part and parcel of this indemnity agreement? What level of influence or information or assistance did they give you in terms of forming this indemnity agreement, which is now at the center of the largest and biggest and most humiliating scandal to hit Trinidad and Tobago in its 60 years of independence, as MP Rambally would have indicated? We need every single one of them, not only Stuart Young, but this little thing that he sent out here today, to come out and indicate their position. We need every single person called by their colleague, their partner, their buddy, Faris Al-Rawi, to come out and indicate clearly what their position was with respect to this indemnity agreement. I didn't call your name. MP Rambally didn't call your name. Faris did in response to questions sent to him by the DPP and the police. We want to know your position. It is important. And after all of this having played itself out, the best thing that Faris Al-Rawi could do is as he normally would do, deflect. Well, it's not me, it's senior counsel who settled the document. Go and ask him a question. It's not me, I passed the information on to Jenkins and the DPP. It's not me, who filed this claim against the state with respect to this incident with the indemnity. It's Shankar Bedesi. And as we're talking about Shankar Bedesi, let me tell you something. Shankar Bedesi is a well-respected attorney at law in this country, serving on the Law Association of Trinidad and Tobago, I think as secretary. I don't know if he's still there, but he did so for some time.
For well over a decade, I would take it.
For some time, and has developed a very, very good reputation. Don't try to cast any aspersions over Shankar Bedesi picking up any matter against the state, right? And it would serve the public very well to know that Shankar Bedesi was not the lawyer who initially filed the claim against the state on behalf of Vincent Nelson. There are 3 attorneys' names who are on that paper, on those pleadings, as it is now unsealed, as far as we are aware, right? Who filed that claim first and filed an amended version of the claim form and statement of case, and then Shankar come on board. And 3 of those lawyers, they belong to our chambers, right? Are members of our chambers, because it is on the filing papers, that are well connected to a sitting PNM MP who's also an attorney at law. So I don't know what foolishness Faris was trying to peddle in terms of calling up Shankar name. That has nothing to do with Shankar, right? This is the position that you have found the government in, as embarrassing as it may be, and we need answers. And I want the public to also be aware, because a lot of other persons would have come out to comment on this matter. One of those persons is Pamela Elder, senior counsel, well-respected attorney at law, senior counsel as she is, and Faris as well too in his press conference. If there was anything at all that he was very, very candid about, is that Mrs. Elder is an extremely good attorney, and that is maybe the only thing in that press conference I would agree with Faris Al-Rawi on. And she indicated that millions of dollars in taxpayers' money was spent in the persecution of former Attorney General Anand Logan, raises issues of misbehavior in public office on the part of former Attorney General Faris Al-Rawi. These are the words of Mrs. Elder, a senior criminal attorney, well knowing the elements and ingredients for such an offense, right? She indicated in a telephone interview to the Express that Al-Rawi, Elder said a statement submitted by Al-Rawi to the DPP, which contained exhibits, disclosed astounding fees paid to a junior attorney in Trinidad and Tobago and United Kingdom attorneys. Elder said that the documents which showed claims by attorneys locally and in the UK for outstanding balances, so this is after he paid them a set of money, to the tune of hundreds of thousands of British pounds. Not Trinidad and Tobago currency, British pounds. That is what these people calling for, in addition to the money that they were paid in terms of their involvement in this entire fiasco. And she went on to say that this raises issues, and I'm being very circumspect in my statement, but in light of all my years, Elder's years of experience as a criminal attorney at law, it raises serious issues of misbehavior in public office. because it is a money trail of millions, and I am speaking of millions of dollars expended in the persecution of Ram Logan. She went on to indicate that it is of extreme importance whether these monies were spent without the DPP's knowledge. We go back to the DPP. She said it must also be known whether the monies expended to Nelson for legal advice and representation was brought to the attention of the judge at the plea bargaining hearing. These are certain specific things that she's pointing out because it is totally related to how this matter was conducted and passed itself, traversed itself through our court system. As I said before, weaponizing things that should not have been. She goes on to say this is not a light matter. It is extremely troubling, and that the prosecution of this matter has been undermined. And by whom? An overreaching, over-ambitious fella from San Fernando West. This is the position that we are in because of him. And a lot of persons, commentators, have come out to indicate what their positions are. And we are thankful for that, because MP Rambally was right. Some of us within this country, civil society and others, we have a voice when it comes to anything to do with the UNC. Any and everything to do with the UNC, there's something to say. But as it pertains to wrongdoing under the PNM, we become mute. We become silent. And it was very welcoming to see the Southern Assembly and the Criminal Bar Association come out to indicate lucidly their position. But we also, as a responsible opposition and a government in waiting, call upon other members of civil society to come out and give their own opinions on this particular situation. To call on, as I mentioned before, the other cabinet ministers whose names were called by their own colleague. It's not Rambally and Sobers call their name, it's Faris who call their name. Come out and clear the air on this particular position, because there are implications for the common man on the street watching on. That the pillars of democracy in this country have all not been shook. We passed shook long time. They've broken down. And that persons in this country will no longer have faith in the justice system, because they will understand that justice can in fact be bought, which is what that indemnity agreement in my estimation amounts to. Confidence has been lost, and we need as a responsible members of this country to attempt at all costs to restore that confidence that has been lost. And I want to leave you here this morning as I hand it back over to MP Rambally to conclude. Martin Daly Senior Counsel would have had an article entitled Akin to Bounty Hunting. And I read the article, a very, very interesting article. He didn't mince words in that article at all. And the last part of the article is what caught my eye the most, and it was etched in my memory. He says, it is clear the reason why the prosecution of the accused collapsed is that Nelson, the main witness, has tied up the state in litigation arising out of Al-Rawi's dealings with him, and in respect of which Al-Rawi strayed far from his constitutional section and dealt with people. And I could not agree more with this MP Rambally. And dealt with people who were far more clever than him. MP Rambally?
Thank you, Mr. Sobers. Mr. Daly is someone whom I served under in the Law Association, Council of the Law Association many years ago. And someone who I know he has legislative experience. He sat as an independent senator. He's, of course, a contemporary commentator.
Yes.
And, a brilliant, senior attorney at law, senior counsel. Mr. Daly has, and I think everybody accepts, he has a very commanding power of grammar. And so when he speaks, he chooses his words very carefully. And it is noteworthy that he has found another way to really, call out Faris Al-Rawi's unscholarly statements that you were referring to at the recent press conference. And the heading of his commentary today is akin to bounty hunting. And one of the things that the window commentary says, this is what Mr. Daly says, senior counsel. Tolerance of subversion of good governance. So tolerance of subversion of good governance will have negative consequences, regardless of race, shade and political party. That is an extremely powerful statement in talking about our democracy. So I just want to, Sean, to go through some of the articles for the benefit of those who are watching on. Today's papers, and this is why we said at the very beginning that the papers today, all of the main, the daily newspapers, print newspapers, they paint a picture of what is clearly now the biggest, I can't say that enough or emphasize it strongly enough, the biggest scandal in our 60 years as an independent nation. When we look at I start with the Express, and Ms. Anna Ramdas is the reporter. The title of this is Nelson's $100 million claim unsealed. Alleges Al-Rawi promised him a presidential pardon. That is another issue. I mean, this is what it says. And we know these are more senior, they are very expert reporters. And Ms. Anna Ramdas, it says, state witness and whistleblower Vincent Nelson is claiming then Attorney General Faris Al-Rawi promised a presidential pardon would be given to him if he gave evidence against former Attorney General Anand Ramlogan and Attorney General Ramdeen. So it comes back to what Mr. Sobers and I are saying and what we are as the opposition saying. They were prepared and they did in fact pull out all of these stops. They would stop at nothing to ensure that they persecuted Ramlogan and Ramdeen. That is what they set out to do. That is what they intend to do, and that is what they have been doing. So this is where you are seeing, based on this pardon promise, another part of the article, the claim stated further that, and it quotes, a pardon would be fast-tracked to be provided within 1 month of the claimant being sentenced on the condition that the claimant give evidence against Mr. Ramlogan and Mr. Ramdeen.
Shame.
So the money is not enough. The indemnity is not enough.
Shame.
Right? Paying for lawyers is not enough. Right? Refusing to share information, or agreeing to refuse information to other tax authorities in other jurisdictions, regardless of whether or not the Shylock of Trinidad and Tobago, Nelson, whether or not he was actually in breach of their laws too. We don't want to share our information with them. That wasn't enough. Now they are trespassing into the presidential function by promising a presidential pardon to him.
In quick time too.
In quick time, within a month. I mean, and you have people who are applying, and we don't even have a mercy committee. Who on the mercy committee, whether they sit in, what they're doing, if they're being paid a stipend, who knows? Nobody has a clue. But here it is, these fellas, right? Al-Rawi and et al., they are promising presidential pardon within record time. So another thing that surfaces in this here is that it speaks to Nelson's civil claim, and so I will not repeat what Sean Sobers has indicated. Mr. Sobers has done an extremely good job in comprehensively getting down into the details to show the conspiracy. Just for the purposes of pointing persons to what the articles say. It is not Sean Sobers saying it. It is not Dinesh Rambally saying this. It is not the UNC saying this. This is what is reported. And what they are making clear. There was a meeting. There was a meeting at the ex-AG's home. That is the rubric heading in this article. The claim stated that Nelson's attorney met with Al-Rawi at his home. Mr. Sobers, I hope you don't see clients at your home.
I don't. That's why I pay rent at an office.
Right? And I don't want clients calling me that they say, okay, well, I see the Attorney General seeing people home, so we should come home by you. That is not how professionals conduct themselves. The claim stated that Nelson's attorney met with Al-Rawi at his home. On 24th November 2018, the claimant's TNT attorney met with Al-Rawi at the latter's house, meaning at Al-Rawi's house, stated the claim. It added that Al-Rawi was informed that due to disclosure of the notarized statement to the National Crime Authority, well, this is really the CPS, right? Nelson was being treated as a suspect. That is the UK authorities we are referring to. Was being treated as a suspect under the Bribery Act and likely to be prosecuted and imprisoned in the UK. So there isn't a letter, maybe there was, but it is not stated here. This claim that Shylock of Trinidad and Tobago, Nelson, has brought, he is saying clearly that his lawyer went to the home of the Attorney General to tell him what was taking place in relation to him and the UK authorities, right? And potential charges, etc., that he could be prosecuted and imprisoned in the United Kingdom. Mind you, Trinidad and Tobago, this Shylock of Trinidad and Tobago, Vincent Nelson, he is right now probably in some vineyard, Italian vineyard in Italy, sipping some fine, refined wine. Who knows what he's doing right now? And here we are in the midst of a scandal after, and we will get to this point, after having expended to the tune of millions of dollars and yet to possibly be burdened with more money, more millions. So this is something that the Express has pointed out, and this is what is reported as Nelson stating in his claim against the government. Now, I move quickly over to the release of Minister Stuart Young, and he says that the matters surrounding Vincent Nelson are sub judice, and accordingly it is prudent for him not to say much or be drawn into attempts to obfuscate the truth or to jeopardize any ongoing legal matters. The obfuscation of the truth and the jeopardizing of the legal matters, they have already taken place between 2019 or thereabouts coming up to 2021, with Faris Al-Rawi stepping out of his crease, getting himself involved in matters which don't concern him, which he has no power as Attorney General to engage in. That is what we see from the various commentaries, including that of Martin Daly, Senior Counsel. And getting involved in these matters, you have now compromised the criminal proceedings. You now come in to say that you don't want to say anything which will obfuscate the truth, when all the time the leader of the opposition was calling for answers, was talking about sale of a vehicle from Minister Al-Rawi to the attorney for Nelson, Roger Kewal Singh, and now you're hearing about the attorney for Vincent Nelson going home by the Attorney General to talk these matters. I mean, this really, Trinidad and Tobago, I don't know what language to use, but this stinks to high heaven, you know. This is really a massive scandal of the highest order. So it goes on. I mean, this goes on. I just want to go quickly. Conversation. So you have one person for Shylock of Trinidad, Vincent Nelson, the attorney, going home by Faris Al-Rawi. As if that was not enough, Trinidad and Tobago. King's Counsel claims he had a conversation with Young on airplane. This is not UNC saying this, you know. And this is what it says. The rubric heading, this is page 5 of the Express today. Conversation with Young on plane. The claim stated that on October 5th, 2018, the NCA advised Nelson in writing that it was in possession of a notarized statement that he was subject of a criminal investigation pursuant to the UK Bribery Act and that they required to interview him. It stated that Nelson's attorney and Al-Rawi had exchanged text messages about this, and Al-Rawi was aware of what was going on. And they quote the claim now. At all material times, the defendant Al-Rawi had informed the claimant's Trinidad and Tobago attorney at law that Stuart Young, then a minister in the Ministry of the Attorney General, had wrongly disclosed the notarized statement without his knowledge and or permission, stated the claim. So this is what they're saying the claim says on the part of Nelson. This goes further. The claimant informed Stuart Young and the defendant had informed the claimant attorney that the notarized statement had been disclosed by Young. So Nelson, so Trinidad and Tobago, understand this. This indemnity agreement that Nelson entered into with Faris Al-Rawi, that indemnity agreement, he insists and he's holding strong to the fact that that must, at all costs, Trinidad and Tobago now has to ensure he is not prosecuted anywhere in the world. And we must pay all his legal fees. That is what that agreement says. And what it says here now, in his claim that he has brought a civil claim against the Faris Al-Rawi and Trinidad and Tobago, he is saying that in the claim that Faris Al-Rawi communicated with him that that indemnity agreement was disclosed by Minister Young to some foreign authorities, whether it be the UK authorities or whosoever. Listen to this. This taking place in an aeroplane, you know. I mean, it's only really in Trinidad this could happen under PNM, you know. The latter replied that as a lawyer, so they are talking about Minister Young responding to Nelson. So Young is telling Nelson, as a lawyer, he wouldn't be so stupid because he knew it would be a breach of the agreement. This is what is being said here. I want to say to Minister Young and Minister Al-Rawi and Prime Minister Rowley and all of them, you ain't going to get to hide behind no sub judice rule with this, you know. This is a matter. Sub judice rule is if we are talking about the merits of a matter which is likely to prejudice the findings in a matter. We are not talking about the merits of the matter. We are talking about the fact that it is clear as daylight that something took place which led to the discontinuance of criminal proceedings. The country has rights. They invest their rights, and one of their rights is to ensure that when there are criminal prosecutions, that prosecutorial decision to move further with a case, that it is in the interest of the people, that there is fair and due access to proceedings, to access to the courts, there is due process. And this is something that is not taking place in this particular matter. And in addition to the conduct of the ministers of cabinet, it led to the total collapse by reason of an indemnity agreement. You imagine now Nelson is saying that he is not going to give evidence until he gets his pound of flesh. That is what he is saying, you know.
Taxpayers' pound of flesh. We paying that. Instead of running this country properly, we and just to segue in, just a tad bit, MP Rambally, we've always been, as an opposition, members of the country generally, citizens of Trinidad and Tobago, have been complaining why this country is going down this treacherous path. Why nothing that the government touches could turn into gold. It is because instead of studying to run the country, they're looking to politically victimize and witch hunt people. This is something deliberate. They didn't cook this up in our backyard room the other day. They took their time with this. And this is what they are doing instead of dealing with the issues that face men and women, children in this country. They don't have any time for people like you, like the normal citizens. They're looking to politically victimize. They're looking to go after MP Rambally and MP Lee and all of these people who form the part of the opposition, who stand as bastions of truth and democracy. That is what they are concerned with. Political victimization, not running a country.
I agree with you. Citizens have no doubt about it, you know. After today's press conference and having regard to how the leader of the opposition has been marshalling these matters, and now the egg has broken in their faces. This is something that you will see the nastiest, the dirtiest tricks and ploys that the PNM can employ, that they will bring against my colleague here, Sean Sobers, and they will attempt to bring against me. You all of a sudden you will start to hear that I involved in some scandal or live in some kind of lifestyle that, you know, I never knew I myself I was living. Have no doubt about it. It will happen because this is the PNM's modus operandi. But unlike my colleagues, Mr. Sobers, I will not come quietly if they come with this persecution. So that is a warning I want to send them very clearly. And getting back to this, you could imagine, but I like this, you know, the latter replied that as a lawyer he wouldn't be so stupid. Well, I wouldn't want to go there. Let's leave that as it is. So that is the Express. Ladies and gentlemen, if you all cannot find a copy of the dailies because it has been sold out on account of this scandal, you could pass by the leader of the opposition office and I'll give you my copy. Right? I want to go quickly to the Guardian. And this is something that I want to point out before we conclude, Mr. Sobers, because I want to get your 2 cents worth on this as well. What they are saying here in, this is page 6 of the Guardian, and the title again is Young Gives Nelson's Notarized Statement to UK Crime Agency. Now, listen to the tragedy in this whole thing, and the stupidity in this whole thing. Imagine an Attorney General who has no power authority to engage in this criminal prosecution. He takes it upon himself to now enter into agreements, to start negotiating. You have heard Mr. Sean Sobers is asking how that was initiated. Who took the first step? Did Nelson seek out Faris, or was it the reverse? But this is where we have questions that need to be answered. Remember, Nelson was acting in that infamous Malcolm Jones matter and litigation. So, you know, just like how one attorney could reach home by the house of the Attorney General, then likewise, we don't know who was talking, how and when and what they were doing, the backdoor negotiations, right? So they're saying Young gives Nelson notarized. So you imagine You as the Attorney General did something you had no authority to do. On top of that, what you in fact did, you're saying that you were advised by 2 senior counsels. So you mean to tell me, according to the Attorney General, that is, and not according to me and Mr. Sobers, according to the AG, those 2 senior counsels in settling that agreement didn't tell you you can't enter an agreement to breach laws?
Yeah.
You want to tell this country that you could enter an agreement with somebody to breach laws, and not only that, breach other laws? And this is what this goes into here. Somebody seems to have a sudden change of heart, because the Sunday Guardian, and I'm reading here now, understands that the investigation by the NCA into the King's Counsel, meaning into Nelson's, into the King's Counsels, had prompted the agency to ask for the information provided by Nelson as it related to the other attorneys under investigation and not Nelson in his case. And they quote, they're quoting a source, I assume this source is from the AG's office. It is not a breach of the indemnity, as you will see the undertaking is subject to the AG's obligations at law and under statute, one of which is the Mutual Assistance in Criminal Matters Act, as well as common law duties, a senior legal source said. Another legal source said under the Mutual Assistance in Criminal Matters Act, there is an obligation to provide NCA, meaning the UK authorities, with the material for its parallel investigation into the prominent King's Counsel solicitors. Documents obtained also indicated that the NCA later allowed the Trinidad and Tobago government to take the lead in the investigation and get Nelson to provide whistleblowing evidence to Trinidad and Tobago Police Service, etc., etc. So it brings me back to the question, how could they have agreed in the first place to hide notarized statements from the UK authorities and the Crown Prosecution Service in England? Would this not have violated the same Mutual Assistance and Criminal Matters Act? And would we not be in breach of treaty obligations? We already on some blacklist and fighting to get on a grey list and what have you. We already are there. The Falklands, I think it's the Netherlands, their parliament has just put us, and they call us, according to them, they say Trinidad is now in a nook of shame. It seems as though, and that is what this points to, it seems as though they are now trying to deflect blame for the breach of the agreement. Somebody is seeking to blame. Maybe Minister Young is trying to put the blame on somebody else for the breach of the agreement, according to Nelson. So one wonders whether correspondence already sent, and well, it seems as though that is the other side of the story that we would want to hear from the ministers. I think very quickly, there's one thing, Professor Hamid Ghani, and today it says judicial politics, and he says very nicely, the doctrine of individual ministerial responsibility has 3 arms to it. Namely, 1, the advice rule, the culpability rule, and the propriety rule. Every minister is entitled to departmental or other advice before making a decision. So fine, Minister Arawi was entitled to seek that advice. He claims he sought and, had Senior Counsel Mendez and Gilbert Peterson, Senior Counsel, settle the document. However, the decision is the responsibility of the minister alone. Minister Arawi, get that clear. The responsibility is that of yours alone and not that of your advisors. Mind you, I still ask the question whether they in fact said that you could enter an indemnity agreement to breach other laws. I can't understand how that will work. The propriety rule applies to the personal conduct of the minister while in office. So I just pointed out, it is not my duty to advertise the papers today, but it is good reading because it is a scandal of massive proportions. And one of the things is Jada Lautu, who is another expert reporter in the Newsday, how the case collapsed. And I just want to say, it is quoted here. Immediately after Nelson's sentencing, Arawi told Newsday, listen to this, sir. This is something that I want to point out. So people, I am going through this trouble and alongside Mr. Sobers because I don't want people saying, UNC saying this. These are hardworking reporters. They are expert journalists, and they have taken the time to unearth these things for the benefit of our democracy. It says here, immediately after Nelson's sentencing, Arawi told Newsday Nelson's sentencing was historic. So she's quoting Arawi. He said Nelson's sentencing was historic. This case was a historic case insofar as Mr. Nelson's whistleblowing testimony, voluntarily given, resulted in his conviction and sentencing before a court. Faris Arawi, if it was voluntarily given, why the hell the need for that indemnity agreement? And it quotes, I go on again, what is important in the Nelson matter is that all of the dots which were out together in the criminal justice reform went to work. Maybe that's what you were talking about, the series of
Coming to
piloting different bills. Yes.
Deliberate.
And they quote Arawi, there has never been a case of this type with the quantum of sum as it is, and the allegations standing as they are. True. Faris Arawi, you are speaking the truth for once.
Yes, yes.
So this is what he said. Maybe it was premonition on his part when he said this, whenever in 2020 with the 2019, sorry, with the sentencing. Those allegations no longer stand for now. So this is going back to the reporter speaking now. Arawi has told the police Nelson's former attorney, Roger Kewal Singh, contacted him about alleged corrupt dealings with the two attorneys, and they quote Arawi again. He informed me, so Arawi is saying that Nelson's attorney informed me that Mr. Nelson was deeply concerned about his personal liability in the matter, but that Mr. Nelson was fully prepared to disclose those matters and supporting evidence, but that he wished to be indemnified in consideration of the same. So what they're really saying is trapping themselves into saying that on the one hand, this indemnity was drafted to entrap or to induce or to so-called bribe Nelson. But when Nelson started to pick up back on them now and insist on his pound of flesh, the first thing he asked for, he said, but look, UK authorities asking for me. One of your ministers send this document to the CPS in the UK. And when he realized that now, hear what he come, and Arawi is saying that Nelson's attorney came to him and said, on behalf of Nelson, listen, it gone already, Seeing that it gone, I want to be indemnified for all the damages and all the fines and whatever he's found to be guilty of over there in England, he must now be indemnified. That is why you have this big bacchanal now, and scandal. So he informed me that Mr. Nelson was deeply concerned about his personal liability in the matter, but that Mr. Nelson was fully prepared to disclose those matters and supporting evidence, but that he wished to be indemnified in consideration of the same. Arawi received Nelson's statement on October 26, 2017, and said as a result, he signed the indemnity agreement on behalf of the government in November 2017. What does this mean? Am I repeating this for repeating's sake? No. I am saying this to bring you back to the point that the DPP has made it categorically clear that he had absolutely no knowledge of this. He had no knowledge of any indemnity agreement. And there's one other thing that, one further article, which I don't wish to deny the population of Mr. Sobers. And this is the Express Opinion column. It is titled Nelson's Shady Presence. In this shady saga of Vincent Nelson's involvement with the Rowley administration, there is also history to be considered. So again, it is not Mr. Sobers, it is not myself, Dinesh Rambally. This is not the first time that Dr. Rowley has gone into denial mode in a matter involving the disgraced British King's Council, whose refusal to follow through on a deal with the government led to last week's dramatic collapse of the case against two major figures of the former government, former AG Anand Ramlogan and former Senator Gerald Ramdeen. So this is the Express commentary, their major opinion column, and it is saying that it is not the first time Rowley has gone into denial mode. In March, Dr. Rowley's attempt to distance himself is a virtual replay of the other matter involving his government and Nelson. Which matter is that? We refer to the withdrawal of Petrotrin's US $109 million lawsuit against its former chairman, the late Malcolm Jones. Who provided that evidence? None other than the Shylock of Trinidad and Tobago, Vincent Nelson. In March 2016, as news broke of the collapse of the case against Jones, the Office of the Prime Minister issued a statement saying the decision to discontinue it was made by the Petrotrin board, acting on the advice of its own team of lawyers led by Vincent Nelson, emphasizing that while the Attorney General is the advisor to the Cabinet, this particular matter was never the subject of Cabinet or government involvement, but solely a matter between Petrotrin and its legal advisors. Deja vu. This is deja vu for this country. The Prime Minister's position flew in the face of statements made by then AG Arawi, who had told a news conference that his office And Petrotrin had been forced to take the decision after their legal team, led by Vincent Nelson, advised that Jones had a good chance of defending the lawsuit. Arawi was also involved enough in the case to disclose the legal tab was at $45 million and counting. 3 weeks later, in a curious development, the Petrotrin board issued a public statement saying Petrotrin's then chairman, Andrew Jupiter, had not participated in the decision to withdraw the case due to his absence. But I leave that right there. I don't want to dilute what we are on. So, ladies and gentlemen, you have heard it more than what we had anticipated to give in terms of a contribution to you, to enlighten you this morning as to what is the state of Trinidad and Tobago holding the government to account in this scandal. And I say that we are given more because, again, I point out to the fact that all 3 daily newspapers have had a lot to say with respect to this. And why is it that they have a lot to say? No, don't let the PNM fool you that the media is against them and they're agents of the UNC and all of those things. That is what you call really. That is hogwash and that is, yes, mistruth. This is because the country accepts, the country is irked. Everybody wants to know that if you are facing the courts, that you get a fair trial. That is what everyone wants to know. And they want to know that if you are guilty of the crime, that you be convicted. That is what they would like to know. There was none of that. There was no fair trial in this, and therefore there was no ultimate trial. And even the accused in this particular instance, they never got to see their day in court so that they could prove their innocence. So I hope that the public understands what is at stake here. Prime Minister Dr. Keith Rowley and former Attorney General Faris Al-Rawi have failed in their oath of public office and instead engaged in a series of illegal actions which are an abomination of their responsibility to safeguard the public interest. As I conclude, I want the public to know this. This matter, Mr. Sobers, is no longer about Mr. Nelson, who, as I said, by the way, sipping in the vineyard, right, in Italy right now, some refined brand of wine.
Eating pizza, okay.
Right, eating pizza and, nice delicacies and stuff, right? It is not about Anand Ram Logan or Gerald Ramdeen. This is not even about so much PNM and UNC, that political struggle, This is about the rights and the freedom of all the people of our beloved country. Great freedom fighters in the history of our world, of democracy in all developed nations, have bled for the very safeguards we have in our own constitution. If we allow this PNM regime to get away with these heinous crimes, destroying our liberties and assaulting our rights, we will be effectively aiding Rowley in imprisoning us all in his dictatorship. And this is why we must take the actions of the Prime Minister, Dr. Keith Rowley, and former Attorney General Faris Al-Rawi, Minister Stuart Young, Senator Sagram Singh, and AG Amor, and possibly it may even involve the Minister of National Security, and anyone else involved in this sordid and illegal scandal. We must take their actions to task. And I repeat, police service, do your bloody job. You need to get down in the trenches and you need to show your independence now. This needs investigation at all levels. This regime is devoting all of its energy and attention to destroying your rights, my rights. Meanwhile, your children are starving, schools are collapsing, hospitals failing, roads falling apart, water and lights are now hit and miss in some communities. And we paying monies, and we would like to know how much fees have been paid so far. What we do know is to the tunes of millions of dollars. What we don't know is exactly how much and how much has gone by way of former lawyers, present lawyers, and we'll have to see future lawyers as well. So we need to know, our citizens deserve better than this, ladies and gentlemen. And our people demand better than this. And I hope that this morning, Mr. Sobers and myself, on behalf of the Honorable Leader of the Opposition and all of our colleagues and members of the United National Congress, a government in waiting, we hope that we have been able to enlighten you and shed some light, further light, on this whole scandal and saga. So I don't know if the members of the media will have any questions. We will take those questions now. Mr. Sobers.
You have two questions coming in. You described this indemnity as a coup of the Constitution.
Yes.
You believe it's akin to a coup?
Yes, the reason why I say it is akin to a coup, it is because you had, over a period of time from about 2017 to 2021 into this year, you had these steps, these subversive steps, these steps which are without authority. They are being taken without legal authority. They are being taken to subvert the course of justice. And that is why I say it is akin to a coup on our constitution and the rights of the people of Trinidad and Tobago.
Senator Sobers, in your presentation, you appear to insinuate that the indemnity was not drafted by the eminent senior counsel that the former Attorney General indicated. Is that your belief that this indemnity was drafted by someone else?
No, number one, based upon the press conference that Faris Al-Rawi had earlier this week, he indicated that the indemnity agreement was drafted and it was settled by senior counsel. In terms of legalese, in terms of how we speak sometimes as attorneys, when we say a document is settled by, it is usually prepared or drafted by one lawyer and then a more senior attorney who may be more okura or intimate with that particular area of law would review the document and ensure then that it is fit for consumption, fit to move forward. I have asked the question here this morning because it is an important and pertinent question. Based upon that statement made by Al-Rawi, I want to know who drafted the indemnity agreement. We are aware as to who settled it or who may have had eyes on it or who looked at it or who had some part to play with respect to it. But I want to know who drafted the document. And it is extremely important for us to know, because based upon what MP Rambally would have been reading coming out from the newspapers, being reported by the newspapers, you have situations where it is possible then that Nelson may have drafted it, his lawyer may have drafted it, Faris may have drafted it, the state, somebody from the state may have drafted it. We aren't sure. We aren't sure. And it is important, especially with respect to the revelations coming out of this morning's press conference and all that is being placed within the weekly newspapers. We definitely have a lot of answers, but we have also a lot of questions. And it is incumbent upon these actors within this play to give the answers that are required for the state and the country to move forward, for us to breathe. And essentially and eventually, it is our hope, based upon those answers, that the TTPS could get involved and lay charges if they need to be laid by the persons who are involved.
Also a follow-up to that. In his press conference, Mr. Al-Rawi stated that the first person to file the claim on behalf of Mr. Nelson was Mr. Shankar Bidesi. Based on documents we have seen this morning in the press, it would appear that lawyers connected to the chambers of MPK Scotland were the ones who did that. What is that?
I am aware that in terms of the person, so this claim, from what I've been made aware, reliably been made aware, had about 3 iterations. So you would have had the first filing of the claim form and statement of case, which was not done by Mr. Shankar Bidesi. Then you had an amended version of the claim form and statement of case, which was not done by Mr. Shankar Bidesi. And then you had a re-amended version of that amended version, which was done by Mr. Shankar Bidesi. So in the first 2 iterations of the claim form and statement of case, they weren't done by Mr. Shankar Bidesi. They were done by 3 attorneys. 3 attorneys' names are on that document. And those 3 lawyers are in fact part of a chambers. The chamber's name is Virtus Chambers. It is in fact on the document. And it is a well settled fact, as far as I am aware, subject to being told otherwise, that the head of that chambers is in fact Mr. Keith Scotland. So it was in my opinion, extremely disingenuous for the former Attorney General to indicate that the person who filed the claim was in fact Shankar Bidesi. I think he said that the person who is Nelson's lawyer is in fact Shankar Bidesi. That in fact is true as we sit here and speak. But in terms of filing the documents against the government of Trinidad and Tobago for the breach of the indemnity agreement, it was not Shankar Bidesi. It would have been these lawyers attached to Virtus Chambers which as far as I am aware is headed, or Mr. Scotland is in fact part of that chambers. And as you would be aware, Mr. Scotland is in fact a sitting MP and a member of the People's National Movement.
Well, is it possible that that claim could have been filed by lawyers under Mr. Scotland's chambers, and the Prime Minister and Mr. Arawi not know about it, even though they're all in government?
Well, I think, Mr. Sobers, the point is, and this is the point he was making, the point is, yes, there is that possibility. It's very minuscule possibility. But the bigger point here is that you, Faris Al-Rawi, those proceedings at the time of your press conference, those proceedings were sealed.
Yes.
The public was demanding an explanation. You took it upon yourself to have a press conference. You set the date, you set the time, and in that press conference, you went out there and you misrepresented to the population who the lawyer was that brought the proceedings, as though to deflect. And that is the point. Why would you say something that is wholly inaccurate as to who was the lawyer who initiated the proceedings? I mean, you have lawyers for Nelson coming home in your house, but when it's time to cough up and speak and give accountability, you conveniently forget who the lawyers were. And that is the bigger point. Why are these things being subtly hidden, or an attempt to, deflect? That is the bigger point in my mind.
Mr. Rambally, you made a call for the acting Commissioner of Police to execute search warrants on Prime Minister, Minister Young, Mr. Arawi, and Senator Sargent. Do you think that it is now imperative that the acting police commissioner make a statement on this issue?
Yes, I first of all, before the acting commissioner makes any statement, actions speak louder than words. So I think they really need to do their job, and so they need to start investigating all of these things that are now engaged in the public domain. It is equally open to them. But this clearly, if they need advice, they can go to the DPP. But this clearly paints a picture of perverting the course of justice, misbehavior in public office. And again, on that note, we will have to talk about the Integrity Commission at some point. But in dealing with the police service, yes, they should take the advice if they think they need advice. But to me, from where I sit, it is very clear, and therefore they ought to acquire and execute those search warrants, and then subsequent to that, they can issue a statement if they so choose. And the reason for that is because I am saying time is of the essence in terms of acquiring all of those emails, all of the information that may be stored by devices, cell phones, WhatsApp. That is what even Arawi, I think, said in some of his, he's being quoted as saying that, the communications were done in certain ways, and they need to get those things, because this scandal it will have to head to the courts. It will have to head to the courts. Somebody has to be held accountable for this.
Court.
Yeah, criminal courts, yes. So I hope that answers your question.
First, again, just to go back to the press conference held by Mr. Arawi, he keeps insisting that he knew about this incident.
Well, okay, so if it's, sorry, Sean, you want to take it?
Well, I mean, and I'll be extremely brief, and I'll let Hon Rambally conclude on it. He is saying that, but the DPP is clearly saying something different. And based upon Faris's track record, if I, and the DPP's track record, as a responsible and reasonably minded citizen of this country, if I'm to believe one out of the two, I would believe the DPP, right? Faris Al-Rawi has been caught on a number of occasions, flip-flopping on a number of issues. This is definitely one of them. The DPP has made it abundantly clear, or in the words of Faris Al-Rawi, which always irks me, pellucidly clear, which means the same thing, clear, that he doesn't know anything about any indemnity agreement. And so I would err on the side of caution and believe the DPP and say that he knew nothing about it.
Let me just say something to that, right? There is in the public domain certain documents, and as at this point in time, there are no documents to refute what we have in the media and otherwise. There is a letter which was sent, and I'm trying to find the date here now, 23rd November 2020. And what you see here, these are the BCL solicitors, LLP. These are the solicitors for Vincent Nelson,
Yes.
writing to Faris Al-Rawi on the 23rd of November 2020. And this is what they say. As you are aware, we represent Mr. Nelson, QC. We write to confirm that our client is willing and prepared to give evidence in the trial of Messieurs Ramdeen and Ramlogan. However, in order for it to be possible for him to do so, he would need the government of Trinidad and Tobago to honor its obligations under the indemnity agreement signed between government of Trinidad and Mr. Nelson in November 2017. In particular, the obligation set out at paragraph 5 of the agreement, both in respect of legal fees already incurred and those that will be incurred in relation to the ongoing proceedings. So just to remind the population, this is Nelson's lawyers writing Faris Al-Rawi saying that they want the monies.
Yeah.
What has been incurred and what has to be incurred. As at today's date, the outstanding legal fees in relation to work conducted on behalf of Mr. Nelson by this firm, including VAT and fees of Tom Allen QC, are £275,000.
Pounds.
Pounds, that is British pounds. If required, we are of course happy to provide further copies of the invoices rendered. Listen to this. In addition, the outstanding legal fees of Mr. Roger Kewal Singh, that is Nelson's attorney,
How much?
are £450,000.
Wow.
So I don't know what work there and was done by whom, but the local attorney is charging £450,000.
More than the firm?
And Tom Allen QC and BCL solicitors are claiming 275, almost half, right? The amount of fees in British pounds. The point I want to make, getting back to the question, 23rd of November 2020, that is Nelson to Faris. Faris now writes on the 17th of December to Mr. Roger Gaspar, DPP. He writes, and it is titled Correspondence from BCL Solicitors. So he's referencing what I just read to you, right? By this letter, BCL Solicitors seek to indicate that Mr. Nelson QC is willing and prepared to give evidence at the trial of Ramdeen and Ramlogan. However, they have addressed the issue of payment of fees and require the government of Trinidad to honor its obligations pursuant to the indemnity agreement provided to Nelson. And they say here, as settled by senior counsel. They're slipping that. So this is the first time Arawi says here in writing, as settled by senior counsel. Arawi says to Gaspar, I am mindful of any obligations of undue influence, and as such, I bring the said correspondence to your urgent attention for your consideration and advice. So, ladies and gentlemen, he didn't bring, the question is whether or not the DPP would have known of it. Arawi is writing him here now, 7th of December. Let's see what the DPP says. The DPP responds on the 16th of December now, almost 9 days later. He says, I thank you for apprising me and for soliciting my consideration. And this is the DPP's words. Respectfully, he is addressing Faris Al-Rawi. Respectfully, I decline to proffer any advice to you in this matter, since the handling of same and its potential progenies falls entirely within your purview and that of your legal advisors. Further, it is my considered opinion that it would be improper for my office to associate itself with this development. So here the language the DPP uses. So if we are to believe what is out there and nothing to refute it up to this point in time, the DPP said it in very short sentences, crisp and patently clear, pellucid, that I don't know anything about that. And I don't want to involve myself with that. That is a matter for you and your legal advisors. In other words, he say you take that document you're talking about and you go by whoever advised you, Messieurs Senior Counsel, whoever it was, right? Mendes and Gilbert Peterson. But this is what we have to work with as at this point in time.
Regarding his own potential involvement in this matter, there was a statement today by Minister Young put out this morning where he said that passing on information to credible agencies abroad could never really be construed as a crime. How will you respond to that?
I think I answered this earlier. What it appears, first of all, as a matter of law and as a matter of good governance, you will not enter into an agreement that speaks about hiding breaches or potential breaches of foreign laws.
Correct.
Right? So, as far as I am aware, and I use that term loosely, but I am aware, we don't run offshore sort of banking in this country and have those kinds of, in that sector that is. But for good governance and as a matter of law, you will not hide the commission of criminal offenses to our counterparts, whether it be, Metropol, Interpol, whether it be the Crown Prosecution Service, NCA, whosoever it be, whether it be United Kingdom, whether it be the United States, the authorities in the United States. So that is number one. However, the indemnity agreement says otherwise. It says that he will be indemnified, and it says that this agreement of indemnification will remain secret. It will not be disclosed. So that is the position that Faris Al-Rawi and his cabinet and Rowley's cabinet placed this country in a very embarrassing position with Nelson. What Minister Young seems to be doing now is to be suggesting that no, I don't agree with that position, and it cannot be a breach of the indemnity, and it cannot be the commission of any offense if you supply that agreement to the foreign authorities. Okay. And that, to me, is he will have to explain himself more, but to me, it seems as though somebody is now taking a position, having regard to, as the egg has proverbially cracked on all of their faces, smashed on their faces, that they are now taking the position to distance themselves from that indemnity agreement. But it is too little, too late.
You mentioned the silence by the Law Association. Do you think that given the statute in the association of the senior counsel mentioned by Mr. Arari, that they are perhaps reluctant to make a statement?
I would prefer, I understand that in even reasonable-minded people, that these are doubts that will occur in their minds as to whether these senior counsels who have advised Faris Al-Rawi that they hold, prominent positions within the profession, one, and also I think one of them is in the closely affiliated with the Council of the Law Association. So there would be room for doubt as to whether that somehow is linked to and I use this term on my part, the delay of the Law Association in saying anything. But I don't want to say that as an outright fact for any member of the public to go away with, because I prefer to give the benefit to the Council of the Law Association, first of all. Let them say something and let them explain why it took them this time and whatever else. As far as we know, and Mr. Sobers mentioned, the Criminal Bar Association acted with haste, and in a matter like this, you must act with haste, because it is in the public's interest to not have delay. So the Criminal Bar Association would have, they would have satisfied themselves before they issued that statement. They would have satisfied themselves that the material that they had was sufficient to cause disquiet, and that is their language. They picked up disquiet in what they were reading in terms of the government and the collapse of the criminal proceedings. So they didn't need to delay to see anything else. The Assembly of Southern Lawyers, they themselves acted with some haste, and they put out something as well, and they themselves said that they cannot help but note the disquiet. Those are my words, I'm not quoting them. So they themselves picked up disquiet arising out of this whole scenario, this scandal. And what we have is the Law Association, who is yet to say something about anything, and we will see what happens. So let's give them the benefit of the doubt and see what happens. Sean, any closing comments?
No, I just, at least for me, in my part in closing, it is incumbent and extremely critical and important that some degree of transparency, accountability, democracy, the hallmarks of Mrs. Prasad Bissessa appear to now shine itself or show itself in a situation like this. That the persons who are charged independently to be bastions of justice take up that charge, assume the charge, adopt the charge, and go out there and do what you are supposed to do. You cannot sit on your laurels, on your hands, see things like this playing out in the media, throughout the nation with some of the highest office holders within this country and don't even go and ask them a question. You have to. And that is the only way that members of this country, that the citizens of Trinidad and Tobago, could start to rebuild any form of trust and confidence that they once had within the democracy or the democracy of Trinidad and Tobago, the Republic of Trinidad and Tobago, and to dispel any attempt of any office holder, especially within the PNM, to weaponize those very same things that they've been charged to hold true with respect to their conduct as members of the government of the Republic of Trinidad and Tobago.
It's a question regarding the Privy Council and the CCJ. Do you think given this fiasco, it undermines the intention by the government to move towards the CCJ?
Well, let me. I know that MP Rambally is raring to respond to that question, so I'll let MP Rambally choose to that.
I don't want to take away from the other. I mean, we have spent a lot of time this morning focusing on incompetence, ineptitude, unlawfulness,
Yes.
inducement, entrapment. We have spent a lot of time on what really the sum total is a perversion of the course of justice. If persons who have advised along the way on this perversion of the course of justice, subversion of our democracy, if persons who are engaged in that are coming forward to talk about anything, in this instance the question relates to the CCJ acceding fully to the Caribbean Court of Justice, I want to say that there is no credibility for them to even raise that question. Absolutely no credibility. So they have no authority, no moral right, no suasion, nothing to put them in a position to come and tell any member of the public that we should leave the Privy Council and to move over fully to the Caribbean Court of Justice. Mind you, people continue to mistake. We do have the Caribbean Court of Justice accessible to us in what we call a court of original jurisdiction. So you can, if there's a breach, if you feel you are the recipient, recipient may not be the right term, but you feel you have been aggrieved because there has been a breach of some treaty obligation, you can take any one of the treaty members, including the state of Trinidad and Tobago, before the Caribbean Court of Justice. But we just do not have them as a final appellate court. So I don't think anybody who is involved in this whole machinations subverting our democracy has any credibility to talk anything about telling this country to go to the CCJ or otherwise. I want to conclude before Senator Sobers, I think that's we have concluded
Yes.
all of our items. I want to say that, ladies and gentlemen, the thousands of you who have logged on, tuned in, watching the live stream, and some of you will see it delayed, you will look at it in repeat. I want to say that as citizens, watching our country go up in flames, what do we as citizens have in terms of a recourse against these political arsonists? These political arsonists that they are burning down our democracy. The only thing that we can do is we can demand their immediate resignations and insist on a fresh mandate of governance. And the way to insist on a fresh mandate of governance, Dr. Rowley and his cabinet, Dr. Rowley, you need to call the elections now. Let the country judge really who they want to run this country. Don't just go on a pulpit in the parliament and take speaker protection and, want to rant and rave about whatever. Tobago started the ball rolling recently with the THA elections. Let Trinidad and Tobago, the general public, take their own census and let them say whether they want you to rule or not. I am saying call the election now on behalf of the leader of the honorable leader of the opposition and my parliamentary colleagues, Senator Sobers and myself. Very quickly and on a different note, we will take this opportunity to wish all of Trinidad and Tobago a Shubh, a happy Diwali 2022. I know particularly Hindus, the celebrations don't just last the day of the holiday, right? 24th of October. For Hindus, this celebration of Diwali starts at least 3 weeks in advance. And so you will see lighting up in different communities. You will see different activities taking place, making of sweets, giving of charity. You will see performance of puja and prayers. You will see families getting together, friends getting together, relatives getting together. All of this is part and parcel of Diwali. And in those immediate days, it is 2 days before Diwali, the day of Diwali, and then 2 days after Diwali, you have really the quintessence of 5 days of Diwali. So I wish the Hindus, particularly on those 5 days, Shubh Diwali and all that goes with it. And of course, we look forward to the whole population engaging in the activities associated with Diwali. So, Senator Sobers, I think.
And I would want to echo MP Rambally's expression as it pertains to wishing all our all persons within Trinidad and Tobago a happy, safe and Diwali in terms of their celebrations that are upcoming. And we thank you for tuning in this morning at our press conference, our opposition press conference.
Okay, so let me cut in Sean, right? Sean is smiling. This is on another note. Mr. Sean Sobers, he did tell me, he gave me a warning that he didn't want this highlighted, but Sean, by public demand, and from the honorable political leader herself, members of the national executive to which you belong, myself, my family, the entire UNC family, and I am sure the citizenry for your sterling performance this morning, I want to say happy birthday to you.
Thank you.
All right.
Thank you very much.
Yes. So I want to say happy birthday to Mr. Sean Sobers on his birthday. He's dedicated towards serving a greater public good. So, ladies and gentlemen, thank you very much. Okay.